In March 2015, Adrian Bailey, one of Australia's most notorious predators, was found guilty of 3 more brutal rapes of young women in the years before his infamous murder of Jill Meagher. Saul Holt, QC, his defence lawyer, would have been required to meaningfully consider his own personal ethics and the ethics of being a lawyer before deciding to represent Mr. Bailey. In this video, I'll discuss whether lawyers should or shouldn't represent clients that they personally find morally and ethically reprehensible. I'll answer this question by applying the 4 broad approaches to ethical reasoning in legal practice. The first approach is the adversarial approach, which views a lawyer's responsibility within the strict framework of the adversary system and their role within it. Thus, according to this approach, a lawyer has a duty to advance their client's interests with the maximum vigour as permitted by the law, and also mandates the cab rank rule for barristers with the required skills to defend a client if he or she is available to do so. Thus, for someone like Adrian Bailey's defence lawyer, his personal ethics are not of any consequence, and a lawyer in this situation should defend a client even if they personally find their behaviour morally repugnant. The second approach is that of the responsible lawyer, whereby the lawyer's role is to be an officer of the court and a guardian of the legal system. Personal moral beliefs are perceived to be an irrelevant consideration. And given the responsible lawyer seeks to facilitate the public administration of justice, they're likely to believe that all individuals, regardless of whether that individual's committed a crime that is contrary to the lawyer's belief system, deserves fair and equal access to the law and the legal system, and are unlikely to therefore desist from representing an individual such as Adrian Bailey. This is starkly different from the moral activist lawyer, which stipulates that lawyers should act in a way that most vigorously promotes social justice. Thus, if a prospective client contradicts the notion of social justice, they ought not to represent them. A moral activist lawyer will therefore only represent clients who embody a just cause. And a moral activist would resist representing someone who has allegedly committed a behaviour that contradicts social ethics, such as an alleged murder or rape. They're substantially more likely to focus their energy on law reform activities that serve the public interest. The last approach is the ethics of care. And this is where they have a predominant regard for the relationships that will be affected by the conduct and will seek to preserve relationships at all costs. In most instances, a person upholding the ethics of care approach is therefore unlikely to represent an individual perceived to be morally reprehensible because it's inconsistent with their own personal ethics and because it might impact on the relationships of those in their life. Evidently, there are a number of complex ethical considerations for lawyers. Perhaps the starting point is the recognition of the access to justice and the importance of it. That means that the cab rank rule could and should apply in most circumstances, perhaps with the small exception of situation where a lawyer is so personally affronted by the alleged conduct that it undermines their ability to appropriately represent the client.